I don't know. After hearing him calm and talking about the tether story, it's probable.
Let's go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Probation. What's going on? Third time again. Third time in one day. It's a good day. It's a good day. How's everyone doing? Happy Friday. This is Colin. I didn't say what's going on. This is Colin. Hold on. Let me restart. What's going on? This is Colin. There we go. Now I feel complete. Also, why not? Why not? Why not? How's everybody doing? All right. I feel good. I feel good. Feel good. This clip not gonna make you feel good. Not gonna make you feel good about the fathers of tomorrow. Maybe. I don't know. Maybe he's got a good argument. But it's fun. It's not fun. What am I talking about? I don't even know what I'm talking about. It's not fun. It's interesting. There's some drama. And yeah. Hello, everybody. Before we get started, let's say hello to some people. I'm not on mute. Okay, good. I'm not on mute. Who do we got here? Nancy, who always beats me to my own videos. I'm the one who schedules them, and she always beats me here. Lisa, hi. Another. I said Lisa a second ago. No, yeah, Lisa B. Then Lisa. Yeah, a lot of Lisas. Hello. Sashina's here. KCC sent you, Sashina. Okay. That's good. Melanie, always good to see you. Scroll. I'm going to miss some people because I'm scrolling fast because I want to start the video. Michelle Moreland, good to see you. Neil Morrison. He's my adopted brother from the Irish Demon channel. Mayor, always good to see Mayor. Big Tip Dog, welcome here. Well, welcome. Been here a lot. I don't know where my head is. Phil, hi. Mimi, it's very good to see you. All right. Debs, good to see you. Don, good to see you. All right, I think I caught up. Nope, it just restarted. All right, you know what? I'm just gonna play James, Jonathan. Okay, I see a lot of new names. All right, you know what? Let's just play video. Let's just play some court. Getting carried away, saying hi to everybody.
Can you hear me?
Me, Debs. Me. Hi, Debs. Hello.
Yes, I can hear you.
Yes, ma'am. I can hear you loud and clear.
Okay, great. For some reason, this looks just different. Hold on, let me see if I can change the view. All right, there we go. That looks better. All right, so
it does look better.
I understand that we have
a
hearing. Can you tell me which case I'm looking at?
Yes, Your Honor. This is LaDonya Horton for the Division of Child Support Services. The matter we need hearing on is a matter of James Chestnut. I believe it's position 2 on the calendar.
Yes. Okay. So this is the matter of this is a matter of the Department of Human Services versus James Irwin Chestnut, 22 CH 6578. Mr. Chestnut, are you representing yourself? You need to unmute.
I'm here.
Yourself?
Well, I did want to try to seek counsel of a lawyer to see what a lawyer is gonna say. I did submit a motion to the courts. I'm not sure if you can see that or not, but I did submit a motion to the court.
Did anyone understand that? Did anyone understand that? I did want to send. I know English is hard, but we're in court. He sent a motion. Let's hear the motion.
Okay. And
for continuance. This was I did that. That was yesterday.
All right. And you want to continuance to seek an attorney?
Yes, to try to get advice.
Okay. In the interim, you recognize we'll do a temporary child support number. The child support will still go through today. It'll be temporary until you get an attorney. But you have to bring an attorney back when we do this. Is that what you want to do?
Well, I need to seek advice from an attorney, because at this point right here, I honestly don't know what to do, because I feel like at this point is like almost being taken advantage of.
Well, and that's up to you if you want to get an attorney. I'm just telling you that no matter what, we're doing child support today.
Yes, ma'am.
It'll be temporary. So we'll take the number that the state is presenting. Okay. The department is presenting. It'll be a temporary number. And if your position is you want to come back with an attorney, that's fine. But I also want you to understand, and probably going through this temporary process, you'll kind of see that child support for the most part is done in a formula. It's just put into a system.
Yes, ma'am.
I'm not saying your attorney can't do any better by you. I'm just saying that the number is not going to change significantly unless something is off with the evidence. So if your number is off, that could change the amount. If Miss Rogers' numbers are off, that could potentially change the amount. But generally, the child support is done in a formula that's so it's objective to some extent. There's some wiggle room for the court, but for the most part, that's how it's done. So if you want to get an attorney, I'm going to let you do that. But for right now, I'll grant your motion, and then we're going to move forward on the temporary at this juncture.
Can I say something, Your Honor?
Okay.
The amount they're asking for, which is the I think it's 370 something. I can't afford that much. I will say is, as far as the $100 that is set at, I mean, I can come up on that.
No. I know. What I'm saying to you is I'm gonna set this number a temporary. Your position is you want to continue it, you want to get a lawyer. I'm gonna give you that lawyer, but I'm gonna set this number today based upon what the department has. And then that'll give you an opportunity to get you an attorney, but the child support is gonna go through. So
I don't know what that number is, man.
I don't either. We're gonna go through it now, but it's a temporary number. You can't leave without child support and get a continuance, because then Ms. Rogers doesn't have any money. So I have to do the child support in order to give you that continuance.
Well, could we go over how much they're asking for? Because I don't know if I can even afford it.
Yeah, we're going to go over it now.
Oh, I'm sorry. Okay.
All right, Ms. Horton.
Thank you, Your Honor. Your Honor, this case is actually on the counter for a modification of a child support order.
Oh, okay.
Yes. So there was already a child support order in place in June of 2019, where Mr. Chestnut was ordered to pay $878 per month.
In 2019, and he was ordered to pay how much?
$878 per month.
Okay.
We received a request to review this to determine if there should be a modification. And at the time the request was made, neither Ms. Rogers nor Mr. Chestnut provided information that they were employed. And there was nothing on the Department of Labor that indicated that either of them were employed. So when we made our recommendation, we did make a recommendation to decrease the child support from $878 to $376 per month. And this is for the two children that they had. When we made that recommendation, Mr. Chestnut objected. He wanted it further decreased from the $878. He wanted it less than the $376 when we only imputed minimum wage to both parents. And so in February of this year, because this modification was filed in July of 2022. We had a hearing in February of 2023, and I met with Ms. Rogers and Mr. Chestnut. And at the time, Mr. Chestnut stated that he was still unemployed, that he was facing a situation which was preventing him from getting employment. So on a temporary basis, we gave him concession to give him time to get employment, and agreed to reduce that recommendation from $376 to a mere $100 per month for two little girls. So we've been operating under this temporary $100 per month order since February of this year. So today we are finally here to finalize this, giving him several months to find a job, and then.
Okay, that's different. That changes the
Correct.
position.
He's been well on notice. If he wanted an attorney, this was filed in July of last year. He's had
got
over a year to get an attorney.
Never mind. I thought this was one of those modifications, that this was his first time presenting, being on the count.
No, this is actually the second time this year.
All right. So, Mr. Chestnut, based on that information, the court is not going to grant your motion for continuance because the case has been around too long. If you wanted an attorney, you could have gotten one. I was under the impression when you first came through that this was a new case and you were basically caught off guard by the process, but it's clear that
The thing is, Your Honor, when the case first started back up, I had no knowledge of this case even being started back up. And I went down to
how the case start back up. How does the case close?
The case, Ms. Rogers went up there and closed the case out because we had got back together. So when she went back down there to start the case back up, I had no knowledge of this case even starting up. So Ms. Fulton from the Department of Human Services reached out to me on the phone and said, Mr. Chestnut, I'm calling to speak to Mr. Chestnut. And I said, yes, that's me. She was like, I'm calling to find out, how can we get you caught up on child support? And I'm sitting here like, what child support? She said, your kid's mother came back down here and started child.
Hold on. What child support? He has 2 kids. He doesn't live. This bugs me. I pay a lot in child support. TMI, I've got 2 kids and I'm divorced, so I pay child support. I pay a lot of money in child support. I never like arguments that said like this is too much or what child support. You have kids, man. You have kids. If you have kids and you're not living with her or you're not married, you have to pay child support. That's how it works.
Child support back up on you. She said, do you know your license suspended? I said, no, ma'am, I don't. She said, well, they've been suspended for 2 months. I said, I didn't know that. So she said, come down here and fill out the paperwork and we'll release your license back to you. I went down there. So, and I spoke to the supervisor one time when I went down there and mentioned it to her. And I told her, I was like, I had no knowledge of this case even starting back up.
What time frame are you talking about that you had no knowledge? Last week, 2 weeks ago?
No, ma'am. This is when the child support started back up. I can't recall the date, ma'am, but it was before the when they said that the temporary order of the modification. I didn't even have no knowledge of this case starting back up. So coming to court.
Mr. Chestnut, you're not getting continuance. Okay. But
no, I'm not. I'm just saying I didn't know that this case was even going on, man. Like they got me.
Mr. Chestnut, I'm on a time table right now. I'm restrained with regard to time, and I can't listen to something that's not going to change anything. If you're telling me that if you knew about this case longer than 30 days ago, then we're moving forward, okay? And then I just took a look at your continuance. You did not ask for a continuance to get an attorney. You asked for an attendance because you had a doctor's appointment conflict, for which
I did.
No, for which honestly you evaded and you went to that doctor's appointment without coming to court. You actually should be in contempt. Okay.
I did come to court. Just morning I did come.
No, you didn't.
I showed.
Walked outside and someone was barbecuing. If you know, you know. If you know, you know.
Hold up.
No, you didn't.
I did show up to court.
Mr. Chestnut, I called your case and you don't have, I don't have
I spoke with
Mr. Chestnut, listen to me very carefully. Is this the first time you saw me today?
No, but they're not telling you. I
Mr.
spoke to
Chestnut,
Ms.
listen to my
Horton
question.
yesterday. I spoke
Mr.
to Ms.
Chestnut,
Horton
listen to my
yesterday.
question. Listen to my question, Mr. Chestnut. Is this your first time seeing me today?
No, ma'am. No, ma'am.
When did you answer my call? Because let me go back. If I'm wrong, I'm gonna apologize. But when I go back and look at this tape,
Yes, ma'am.
I called your name and you're lying to me.
I'm not. When you call my, if you not in court, but what I'm saying is, I spoke to Ms. Horton yesterday, and she said she will inform y'all that I was coming. I was running late.
Does Ms. Horton have on a black robe?
I don't, but this is what they this is what they told me, ma'am.
Mr. Chestnut, my staff also reported on the record that you called her and told her you were going to be late, and she informed you what she's supposed to inform you, which is no one can release you but the court, be in court on time. That's what she told you. She didn't. So if I go through the recording and you're telling me she didn't say that, you're willing to face contempt on it. Because if I waste my time.
What I'm saying is, she didn't tell me that yesterday when I spoke to her. That's what I'm saying. I don't know what she told y'all in court, but she didn't tell me that yesterday when I went up to the child support office. I was at the child support office yesterday.
You spoke with my staff and she told you to come to court.
She did. Oh, you talking about that lady? Yes, I did speak to the clerk of court. I told her that I filed the motion, and she said that you still have to come to court.
Right.
When I had spoke to, but originally before I even came down to the court, I had spoke to child support, and then I had went back down there and I spoke to Miss Horton, and she said that she will inform Mr. Andre that I will be in court, that I was running late.
Right. You don't run late.
I didn't know nothing about, I didn't know nothing about I could be released from court or show up late. I didn't know that. I honestly didn't. But I'm just telling you what I was.
You thought you could come to court late because you had a doctor's appointment? You thought that, Mr. Chestnut?
Well, what?
Yeah.
You thought,
no disrespect to the court, man.
You thought that if you had a doctor's appointment or some other conflict, that you could just come to court late.
His name is Jay Chestnut, Your Honor. Jay Chestnut. That's obviously Joey Chestnut. He's a professional eater. He goes to competitions all over the world and he eats. Yeah. He has doctor's appointments. They're important because he eats a lot. And, you know, when you eat a lot, other things happen to your body. So, yes. Yes. He has a Jay Chestnut, Joey Chestnut. Does anyone else get this with me, or is this just me? Just me? All right. All right. It might just be me.
I'm not necessarily saying that, man, but I'm just telling you what I was told. That's all I'm saying. I'm just telling you what I'm told. I'm not trying to disrespect the court or anything. I'm just telling you what I was told.
And I don't know what you were told, but I do know what I said to you earlier. And the first thing I said to you was, you asked for a continuance.
Yes, ma'am.
Because you had a doctor's appointment.
Yes,
you did
ma'am.
not ask for a continuance to get a lawyer, and you're wasting my time, and I don't like it.
I'm sorry, ma'am. I'm sorry, ma'am.
Yes, because you're trying to spin, and I don't like spinning. Okay, because the first thing I said to you was, I wanted to determine whether or not you needed a continuance, because you were very adamant about the reason why. But when I looked at your motion said you had a doctor's appointment. And then I said, you should be held in contempt because you were not here. And then you said, I was here. You know, you were not here. You came when you wanted to come. When I called the calendar, you were not present.
I wasn't present when you called the calendar, but I was just telling you what I was told from the staff at DFATS.
And I was just telling you that you should be held in contempt.
I understand, ma'am.
I wasn't going to hold you in contempt. So there's no need for us to have 5 minutes of dialogue when I've already indicated I wasn't going to hold you in contempt. But I
apologize, ma'am.
I was only making the point that your motion for continuance was not about an attorney, and that I'm going to not grant your motion for continuance because I believe that you were well aware of this case. You knew the child support on yesterday. So you knew enough to have an attorney today if you wanted one. All right. Let me see the number.
All right. No. What are you doing? Why are you leaving? No. I put up another message. I don't remember who said it. You can't super chat because I got demonetized. You can use my link tree, and it's in the description of the video. You can use my link tree, and you can donate that way, and I'll read off your message that way. But no, what's going on? I think this is the end of this clip. Hold on. Let me just play out the rest of this clip. I think this clip's over.
Thank you, Your Honor. Do I need to share my screen?
Ms. Marshall, give her screen sharing capabilities.
Yeah, this is over. It's not over, but I cut it off here.
Yes, ma'am.
I'm hoping I
Is
cut
that
it off
Ms.
here.
Horton?
Yes. And I'm telling you right now, I promise you, the next time I have to have this type of dialogue with anybody, I'm discontinuing Zoom because it's ridiculous. I think for some reason, everybody on Zoom was extremely comfortable with saying what they want, when they want, however.
Yeah, I had to cut that off. They went into their financials, and it was on screen. They showed what both parents made and where they lived, and it went into a full blown custody case after that point. And there was a little at the very end. There was a little bit more I could have clipped out and just fast forwarded for 20 minutes, but at that point, it didn't matter. So yeah, we got what we got out of that clip. Dad wasn't happy. Didn't pay child support. His kids are getting older, and he hasn't paid child support. Yeah, it's on him. But yeah, we didn't miss anything else. We missed about 30 more seconds of that judge. I don't remember her name. That's the first time I've seen her, or the first time I've covered her. She went on a rant about Zoom court. Kind of the same as Judge Bryant a few months ago when she said she was going to take away Zoom court because she was just tired of people on Zoom court just acting like, they're keyboard warriors. She kind of gave the same spiel. That's all we missed is the end of that. I think I have another clip before the main event, but maybe not. I'm gonna play a little bit, and then I'm gonna pause. Oh, yep. All right. This is fun. I went digging. I went deep diving. So you see Victoria Shackleford there on the right. We know her as Judge Shackleford, right? For whatever reason, when I refreshed my YouTube, one of my YouTube tabs today, it popped up 2 years ago, Judge Shackleford as a prosecutor. And it just so happens I have a Judge Shackleford clip I want to show. So we're going to watch a little Judge Shackleford being a prosecutor before we watch her as being a judge. That's what we're about to do. But this is at least 2 years ago. After 1 year, YouTube changes the timeline to 1 year, 2 year, 3 years. So it's in between 2 and 3 years. I don't know how long ago it was, but it was over 2 years ago. In less than 3. All right, let's go. Judge Shackleford as a prosecutor. And Mr.
Are we ready
Goldstein.
on groom?
Look how young he looks.
Yes, we are, Your Honor. You just need to close the breakout room.
Janet Key, which is my stepmom.
No, that's not him.
I'm sorry, we got thrown out of the breakout room for some reason, Your Honor.
He will move you back, Ms. Watt.
It's Prosecutor Shackleford in this clip. I'm not gonna lie. Her hair looks good. Her hair looks good.
Calling 201706, State of Michigan versus Shandon Groom.
Good morning, Your Honor. Victoria Shackleford appearing on behalf of the people.
David I. Goldstein appearing on behalf of the defendant, and the defendant is present via Zoom, Your Honor.
Thank you. This matter is scheduled for PCC. What are we doing this morning?
Your Honor, Ms. Shackleford and I did have an opportunity to talk last night. At this point, I have not received any discovery, but she indicated that within the next day or two, hopefully, she's going to be sending me the written report. I have to get her an external hard drive because apparently there are voluminous documents, videos, etc., pictures, I'm assuming, that she has to forward me to prepare me for the preliminary examination.
And that's correct, Your Honor, but there is one outstanding issue that I raised with defense counsel regarding an order to seal the proceedings, which has been put in place on the co-defendants, as well as a protective order with respect to third parties and discovery. And I'm not certain what Mr. Goldstein's position is on those and whether or not I'll have to file a motion or if it will be stipulated to. So that is an outstanding issue that needs to be addressed prior to discovery.
We will stipulate to that protective order.
And with respect to the order to seal?
Yes.
Okay. And Your Honor, I will send as soon as we're off court today, I will send the orders over to Mr. Goldstein for his review and signature, and then I'll have them submitted to your clerk before the end of the business day.
Thank you. And it's my understanding that this matter is going to be adjourned to February 10th at 11 a.m.
What's going on in chat? Why is Melanie apologizing? What happened? Everyone seems to be okay with whatever Melanie did, and that seems normal. Melanie said something that was probably funny, and now she's apologizing for it? Is that what's going on? All right. That's what I'm taking it as. All right, let's go.
That's my understanding, Your Honor, that Judge Green had set all three that date so that we could discuss the preliminary exam date, which is set for mid-February.
I'm sorry, what was the date of the adjourned date? It's February 10th?
February 10th at 11 a.m. with Judge Green.
Your Honor, I'm going to ask a question, and you may not know since this is actually Judge Green's case. Do you know if she's planning the preliminary examination to be live or on Zoom?
It will be live.
Live? Okay. Okay.
Anything else as relates to Mr. Groom?
Your Honor,
Not
the only
today.
Well, one more issue, Your Honor. Since we're adjourning this date out past the time allotted by the court rules, I would just ask for a waiver to be put on the record or a finding of good cause.
We would waive all times in this matter, Your Honor. It's to our advantage to delay things till we can get discovery.
Thank you.
Satisfactory, Ms. Shackleford?
I'm sorry, Your Honor.
I said, was that satisfactory?
Yes, Judge.
Anything else as relates to Mr. Groom, Ms. Shackleford?
No, Your Honor.
Mr. Goldstein, anything further?
No, Your Honor. Hopefully I'll have that discovery. We can move forward. Thank you.
Thank you. We're all set as relates to Mr. Groom.
Thank you, Judge.
All right, I'll be in touch, Shannon.
All right, now we're in between Prosecutor Shackleford's clips. What's going on? What is? No one seems to be upset, Melanie. I'm scrolling. No one seems to be upset. Everything's fine. Yeah, Melanie, you're good. No one's upset. No one's upset. Oh. All right. If something happened between you and No, yeah. No, don't worry about it. Don't worry about No. He was probably just tired. He was sleepy. Might miss his nap today. I hope he's here and he can hear me. I love No. Well, what happened? All right, you know what? I don't care. I don't care. We're all adults here. We're all friends here. No one knows my friend. Melanie's my friend. Melanie, no one knows friends. So if that's whatever's going on, then it's fine. All right, let's keep going.
Calling 201703. State of Michigan versus Shane Evans.
Good morning, Your Honor. Victoria Shackleford appearing on behalf of the people.
And good morning, Your Honor. Coral Watt appearing on behalf of Shane Evans.
Ms. Watt, you've had the opportunity to speak to your client and Ms. Shackleford this morning.
I have, Your Honor.
This matter was scheduled for PCC. What are we doing?
There are two issues relative to orders that relate to discovery that I've been in discussions with Ms. Shackleford about. And I've also talked to my client about them. The first order that Ms. Shackleford, and I'm bringing this up, Your Honor, because these orders have to be addressed prior to my receiving discovery. The first relates to having all pleadings filed under seal. The second order relates to a prohibition against sharing discovery with third parties. I did go through the second order with Ms. Shackleford and had her remove some language. I indicated to her that I would speak to my client to see if we could reach a resolution as to that particular order, which I thought we did. But my client did bring up a relevant issue as it relates to that order. Oftentimes with my clients, they may have a parent or a close family member that, I will be able to talk to them about the particular client's case. And I do that for a number of reasons, because sometimes they want input from a mom or a dad in making decisions, not just from their lawyer. And so my only concern, while I wouldn't be, providing them with paper discovery, I am just concerned that that will impact my ability to communicate with them. And I mean, as a defendant, he has a right to that, that it would impede my ability to, discuss this case with them as, he has asked me to do already. He's asked me to have some conversations with his mother. So I guess as a resolution, the only resolution that I could suggest, and I'm not sure if Ms. Shackleford would agree to this, is, that I be allowed to, discuss the case with, his mother, perhaps add that to the order. But certainly, I'm sure Ms. Shackleford is going to ask this court to enter the order. I'm just saying that as it's written, I can't agree to it, the order that relates to not sharing any information with third parties.
Your Honor, I don't believe there's anything in the order that indicates Ms. Watt can't have discussions with defendant's family members. The purpose of the order is to protect the discovery in an ongoing investigation. So I don't really think we're in disagreement with respect to that. My order is protecting electronic discovery and paper discovery from being disclosed or shared with any third parties that are not representatives of Ms. Watt's office or the defendant. So I don't think there's really a dispute about it. There's nothing in the language of the order that forbids her from having conversations with defendant's family members.
What I need to make clear, though,
It is Prosecutor Shackleford. Tater Todd, Prosecutor Shackleford. This is at least 2 years old when she was still a prosecutor. I took my face away so you can see it doesn't say judge. This is when she was a prosecutor, which is why I'm showing it. Because the next clip I have is when she's a judge. Let's keep going.
Is when I have those conversations, I oftentimes read police reports because they want to know, well, what are the charges, what's going on? And I just want to make sure I'm not going to turn over a copy of the discovery, but I don't want there to be an issue. I mean, that's disclosing. If I'm reading it to him, it's disclosing. And I'm concerned about being in violation of a court order in doing so.
Have the two of you had specific conversations about whatever provision there is in the proposed order that you disagree upon?
We have, and we have resolved everything except for this issue, which my client brought to my attention, yesterday. And so the only opportunity, because that's when I had an appointment, because we have to make appointments to see him. And so my only opportunity was to bring this to the court's attention today, because I just found out yesterday evening that this was an issue.
So Ms. Watt, then the answer to my question is no, you have not had a chance to talk to Ms. Shackleford about whatever this specific language is that is at issue.
On this issue, no, I have not
Okay.
had an opportunity.
Is this something that can be resolved in a breakout room?
I don't think so, Judge. I think
Okay.
we're going to have to go back to the drawing board and actually go through the order and work out some language. I mean, I do have concerns about Ms. Watt reading these reports directly to third parties. And I think there's a difference between having a discussion with the defendant's family about, the evidence in the case or, the facts of the case without actually reading the reports or sharing, whatever might be encapsulated in electronic files.
But the problem, I'm sorry.
No, I just, a lot of what's incorporated in the discovery of this case has nothing to do with the actual parties, but it's still documentation that I need to turn over to defense counsel as part of this case. So I don't know if there's a way Ms. Watt and I can come back in a few days and maybe her and I can have an opportunity to actually go through it. And if necessary, if we're in dispute and can't resolve it, then we can file our briefs under seal accordingly, and the court can make a ruling.
I would agree, because it's also hard to argue when you don't know what any of the evidence is. So,
Ms. Watt and Ms. Shackleford, what I will say to you is that this case is going to remain with Judge Green. The indication that I've received is that you have an adjourned an adjourned PCC date of February 10th, 2021 at 11 a.m. And I would suggest that if you're able to resolve this issue before then, to submit that proposed order to Judge Green. If you would like me to see if she's available to have a hearing before then, just as to the protective order, let me know and I will step off the bench and see if we're able to get that scheduled for you. What's your pleasure?
Judge, just from previous hearings, Judge Green has indicated that if we weren't able to resolve issues with respect to the two proposed orders, that we could reach out to Ms. Mortsfield and let her know, and that Judge Green would set a date for us after we contact her clerk.
So Ms. Mortsfield is listening to the hearing this morning. I will indicate for the record that the PCC is going to be adjourned to February 10th, 2011 at 11 a.m. Notices will be sent. And I would suggest that you and Ms. Watt, if you're unable to resolve your language issue as to that provision regarding disclosure within the next couple of days, that you do in fact reach out to Heather and get a date scheduled with Judge Green.
that will work, Your Honor. Thank you,
Is that
Your Honor.
satisfactory to both parties?
Yes,
Yes.
Judge.
Ms. Shackleford, anything else in this matter?
No, Your Honor.
Ms. Watt, anything else as relates to today's hearing?
Nothing further, Your Honor.
We're all set. Thank you so very much. Have a good afternoon.
All right, that wasn't crazy exciting. I just, Throwback Friday. It was fun seeing Judge Shackleford as Prosecutor Shackleford. I do need to say, because I don't think I said it earlier, and I meant to say it in the last break, Jonathan Hart, thank you so much for the donation. I appreciate it. TGIF, indeed. I appreciate the donation. All right, last one, because we saw Prosecutor Shackleford. Now we're going to see Judge Shackleford. This one is, this one's, you guys going to have opinions on this. Yep. There will be opinions on this one. Hey, we just saw her. She has a robe now.
All right, this is 22-17-17 SM, the People versus Thomas Montgomery. Can I get appearances?
Matt, please, on behalf of probation.
May it please the Honorable Court, Delamugni, P number 85374, here on behalf of Thomas Montgomery. Tom, please say your name for the record.
Thomas Montgomery.
All right, so we're
Everything-
here today for
everything's a highlight.
probation violation allegation. This is a fourth technical violation, which means you could get the full jail time on this case. At this point, I'm not limited in any way in the amount of jail time you could get. 93 days on this, minus whatever you've already served. Do you understand that?
Yeah.
Yes, Your Honor.
All right, the allegation is that you failed to attend Badver's intervention as scheduled and were terminated from the program due to absences. And then there's also the show cause fee assessed in a balance of $435. You understand the allegation against you?
Yes.
Counsel, did you go over your client's advice of rights form with them?
Yes, Your Honor, we did.
Okay. And
Hi, Heather. I hope your drive went well. I know you're home now. I hope you're doing well. I love you.
I have this signed in date advice of rights form here.
Yes, that's correct.
Okay, so how's your client proceeding with it in respect to this allegation?
So, Your Honor, we would love to accept responsibility for any violation that had occurred, but at this time, I think it's in his best interest to stand mute.
Okay, well, I'll enter a not guilty plea on his behalf. And we're gonna hold a hearing then?
Well, I'd just like to say a few words. I know that Matt had given his recommendation. We're okay with it, just minus one term. So if we could have a moment to discuss what that is with you, Your Honor, you can make that final decision.
Do you know how many times this guy's been in front of me for violating his probation?
Yes, Your Honor, I'm aware.
Okay, he's a problem.
Right.
And I just had to give him a few days in jail not that long ago. And he will not comply with court orders. Like, quite frankly, before you start allocating on his behalf, I want you to understand, or allocating on his behalf, I want you to understand that I think this is generous. Because if Mr. Keys would have wrote terminate probation, revoke 7694A, and give him 93 days in jail, I would have found that to be an incredibly reasonable recommendation. So I want you to know that before you continue. I think that this is probably about the most lenient recommendation I've ever seen by Mr. Keys. But go ahead.
So, Your Honor, I completely respect all the things you told Thomas and I right here, and we very much so respect Matt for the recommendation that he'd given us. Now, the only reason that I have any issue with it is the 1 day in jail. And I know you probably want to cut me off and scream at me, but today I'm not just standing in front of you as Tom's attorney. Today I'm standing in front of you as his childhood friend, somebody who I went to high school with, somebody who I played football with growing up. I know this kid personally. I know that at a human level, he's a God-fearing, hardworking, and smart kid.
Did you read the allegations? Did you read what he pled guilty to? Did you read the facts? Okay, I just want to make sure.
And as a criminal defense attorney, and as you who worked in criminal defense, you know that just because people make mistakes in life doesn't necessarily make them evil. They're not inherently evil.
I agree with that.
And knowing Tom on a personal level and growing up with him as a kid and knowing who his family is, they are a well-respected family and they love him so much. They're here today in the stands. His father, his mother, and his fiance, the mother of his future child who was pregnant, all came out to support him today. Your Honor, I've had people who are being sentenced for heinous.
Who's the fiance or the girlfriend that's pregnant?
Could you please raise your hand to stand up for the court?
What, Your Honor? What's your name?
Brianna Lewis.
Your Honor,
The victim on this case. Okay, go on.
Your Honor, I've had people being sentenced for heinous crimes, facing years in jail, and zero family came to support. He's here for a probation violation. Supports.
As the king of dad jokes, you gotta do better than that. You gotta do better than that. You gotta smile. That's the level that was. You can do better than that, Tater Todd. I know you can.
system came out to see him. He has people who love him and care for him and will keep him in check. Your Honor.
Then why didn't they make sure he went to these visits?
Sure.
I mean, like, he's got one thing he has to do, like, listen, you pled guilty to a domestic violence with a particularly, in my opinion, egregious offense. It wasn't like you threw someone's phone at them. That's not what the allegation here was. And you had a very limited amount of things that I ordered you to do. And you got the benefit, sir, of not getting a criminal conviction on your record for beating on a woman. You didn't get a criminal conviction for that. That's the deal. You got this sweet deal from the prosecutor where you do not end up with a conviction on your record saying that you're a woman beater. And all you have to do is comply with what I asked you to do. And it wasn't like I set out some list of unobtainable goals. I didn't. Mr. Keys, can you find me I need you up here for a sec.
Yes. The orders.
I am glad you're here. I am. And Phil, that's a good point. This is very personal for him. He knows him. That's a good point. Tater Todd. You're up for 3, man. You're up for 3. Your next one better be good.
Let's see. You had 12 months of probation. You couldn't use drugs, alcohol, or controlled substances, which you did. You've been violated for that. You weren't to have any assaultive contact with Brianna Lewis. I don't know of any of that. You couldn't have weapons or firearms. You had to keep a job. You had to go for treatment and follow recommendations. You had to, which you were already doing. This was something you were doing outside of what I just said you have to keep doing what you're doing, right? You were already seeing somebody. I said you got to keep going. You got to keep seeing them. You have to go to batterers counseling. You have to do 5 days of community service. You had to get fingerprinted, and you had to comply with the payment plan. So literally, you can't have guns, you can't beat people up, you can't do drugs, continue going to your therapy, and go to this one class and do 5 days of community service. That's what I mandated. Does that sound reasonable to you, counsel?
It's completely reasonable.
It seems so incredibly reasonable. And he can't do it.
Can't do it.
He cannot get through this.
It's hard.
So, I mean, you can keep going, but if he's entering a not guilty plea and we're setting a hearing, the only issue we're discussing is bond.
Sure. So then how about this? At this point, we'd like to withdraw that not guilty plea. We'd like to accept responsibility for it, but I would like to continue to sort of help you.
Well, if you want to allocate on his behalf, I want to take the plea,
Sure.
and then you can go on.
Okay.
But I think I've expressed my frustration with him and his refusal to comply with the most basic of court orders. So, okay, sir, do you understand everything that's going on here today, Mr. Montgomery?
Yes.
You understand that it's your 4th technical violation, and I could give you up to 93 days in jail. There's a recommendation from probation that I not do that. Do you understand that?
Yes.
Okay. You understand all of these rights that you went over with your counsel on this advice of rights form?
Yes.
All right, and did you sign and date the back of it?
I did.
I heard that too.
You understand if you enter a plea of guilty, you're going to be waiving these hearing rights. There will be no hearing of any kind.
Yes.
We're not going to have a hearing. Matt's not going to testify that he talked to someone over at the batterers intervention place. I mean, we're not going to call anyone in to testify. Do you understand that?
Yes.
And you'd be waiving the hearing rights. Your attorney's not going to cross-examine them. None of that's going to happen. You understand all of that?
Yes.
How do you plead to the allegation that you failed to attend batterers intervention as scheduled?
Guilty.
Were you terminated from the program due to absenteeism?
Yes.
All right, I'm satisfied with the plea. Go ahead, counsel.
Your Honor, I first of all, I apologize for riling you up a little bit. But as I was saying
The
earlier,
minute I saw what the violation was, I was riled up because I'm so sick of seeing Mr. Montgomery on the most basic probation violations ever, but go ahead.
Basicest.
well, this is going to be the last time you see him. And he promised me that. And typically, I can never come in as an officer of the court. I can never come in and advocate for my client and say that I know that this time is different because I don't know them. This is different. I know Tom. I've known Tom for a long time now. And to see him fall down this road, it's hurting me, but I know it's not him. And he wants to change. And the moment he walked into my office and he in the eye, he told me, Abdullah, I'm going to be a father. My wife is pregnant. My fiance is pregnant. I'm going to be a father. I want to turn this around for her. He said, I got a job at Avis now. He said, I work 5-6 days a week now. He said, everything I'm doing is for this child that's going to come into this world. He said, I'm on my way to getting health insurance. I'm 26 years old. I'm no longer dependent. I'm about to get my own health insurance. This is for my kid. If I serve any time in jail, I could lose my job, and that kid is going to end up growing without the necessary means. Your Honor, I know you said a whole lot of things today about what he hasn't done, but I'll tell you what he has done. Sure, he's a struggling addict with alcohol and marijuana and other substances that he may not have disclosed to me, but he checked himself into NA and AA. Who does that? Who does that? How many people can walk up to you, Judge, and say, I checked myself and I know I have a problem. I know I'm an addict.
Is he going to meetings?
I am.
He has.
Are you logging them?
No, I have a sponsor. His name is William Moore. I've been going twice a week to the Salvation Army Center on Warren Road in Dearborn Heights.
For meetings?
Yes, for NA, and then I go to AA to virtual meetings.
Okay, show it to Matt. You're gonna have to start logging your meetings.
Okay.
All right.
So he's checked himself in something that I never see. I have clients that are severely addicted and they refuse to admit they have a problem. For anybody to come forward, regardless of what they've done in the past, and say, I have a problem and I need help, is commendable. And I commend you for that. On top of it, as you stated, he's been meeting with his therapist approximately twice a week. She just gave us a letter. I'm not certain of the gender, but that person has given us a letter, which I have handed over to Matt, stating how far he's come. How far along he's come as a human being and as a person in general, and he's really on the right path. The path back to get on his feet and do the right things. Your Honor, he's completed all service. Like you said, he's missed his DV course, but that ends here. The woman who runs the course told him, this is your last chance, and he said, that's all I want. Just one more chance to prove to myself, to prove to my fiance, to prove to my family, to prove to this court system that I don't want to walk back in here again. I'm going to go to every single course, and that's going to be that. But Your Honor, we beg of you. We beg of you. He made one mistake, and he takes complete.
No, okay. All right. I hear you.
Right.
Listen. Here, is this the log, the absenteeism log? So he's been going to these classes since May.
Are you serious? Why would I do that? Which one are you using? That doesn't make sense.
How many did he have to go to, Matt?
There's 26.
He went the first time. The second week he was absent. The third week was a holiday. The fourth, fifth, sixth, and seventh week he was absent. The fifth week was a holiday, or the next week was a holiday. The next week he was absent. He went to his first class on July 15th, and then he was absent. And then he went to second, third, fourth, and fifth class, and then he was absent. Went to sixth class, and then he was absent again. Like, that's not really a good faith effort. This is what I'm going to do. And I cannot be more clear to you, Mr. Montgomery. You're about to be a father. You know what's really bad for kids to learn? That people hit their spouses. Well, how are you going to raise a child when you put your hands on that child's mother? Think about it. You know what you're going to raise? A kid that's a bully and a kid that puts his hands on women. Do you understand that? Do you understand that kids do what they see? So all I want you to do is go to the class I told you to go to. And you're going to go to the class. Because if you don't go to this class and you don't finish this class, you are doing 93 minus whatever days in jail. Period. This is, if I see you one more time and it has to do with you missing these classes, period. That's it. Because the best thing I can do for you in this judicial system is try and help you become a better man by learning your triggers and learning ways to resolve your anger that don't end up with you putting your hands on that young woman. That's what we're gonna do. And if you miss them and I hear from Matt and I see you again, bring your toothbrush. Do you understand me?
Yes, sir.
Don't bring shoelaces. Don't bring your phone, because when you come in front of me, we're gonna have your little hearing and you're going right back there and you're going to Wayne County for 90 days. Yes, Judge, I understand, Judge.
Yes, Judge, I understand.
Good. I'm adopting the recommendation. I am proud of you for going to AA and NA. I mean, I think that's wonderful progress. But like, and I appreciate that. I run a treatment court. I think that's very important. But I'm not gonna have you violating these orders when you got the benefit of not getting a conviction on your record. You should be thanking me every time you see me.
I do thank you, Your Honor.
Keep this. Don't ruin your life. Go to these classes. This is not an option. This is the most important thing in your life right now, is not seeing my face again. We're gonna give him, when's probation up, Matt? Now.
It's December, I got to look at, I want to say December.
It's coming up.
But
So I'm gonna give him extra probation because I don't have a choice, because you want to be able to finish the program on time. So we'll extend probation by 6 months. You're gonna continue with all previously ordered terms of deferred sentence. We're gonna close once everything's been done, and I mean, there has to be some sort of sanction, right? This is all just saying, I'm gonna give you more time to do it, and then I'm gonna let you keep your status. What's the sanction? What's the punishment if he doesn't do a day in jail?
Give us community service, Your Honor.
How, has he done community service? Did he finish everything he had?
He's finished community service.
He's got 24 hours of community service to be done within 30 days. That's your day in jail. And if it's not done, Mr. Montgomery, I'm tired of seeing you. If I didn't get that across to you, I don't know what will. I am not trying to be mean to you. I'm trying to make you understand you found yourself in the criminal justice system, and there are expectations that you comply with judges' orders. You're not the boss here. All right, we're all set.
Thank you, Your Honor.
Yep.
Woo! Yeah, like I said, Prosecutor Shackleford, then Judge Shackleford. Tater Todd, thank you so much for the super chat. Yeah, more finger streams. What was it? I don't remember. I don't remember what the finger string was to see if these were. I don't remember. To see if they were even, they were straight. I don't remember what the finger string thing was. I really don't. But I think that was it. I think it was to see if your pointer fingers were straight. Something like that. I don't know. I don't remember. But yeah, we'll do more finger strings. I thought that was the last case. I don't know what's coming up next. I really don't. I honestly thought that was the end of it. I'm a little worried about what's coming up next. Not going to lie. All right. I might be pausing this quickly. I don't know. Oh. Reno. Everyone always has room for Reno. This guy's not a good dude. This guy's not a good dude. This isn't a good way to finish it off. It's not a good, let's walk away from this stream feeling good on a Friday night. This is not that kind of case. This is the kind of case you want to throw the book at him. That's the kind of case this is. But it's Reno.
Good morning. In Mr. Marino's matter, probable cause has been found. Public defenders appointed. Are we able to go forward today, Mr. Lucia? Have you heard from the alleged victim?
State's ready to go, Your Honor.
All right, go ahead, please.
Thank you. So we did speak with the victim. We asked them the standard questions. They did not want to, she did not want to be a part of today's hearing. Do you want a no contact order? Yes. I also applied for a TPO. Are you afraid of the defendant? If so, why? Yes, because the defendant tried to kill me. Are you concerned about your safety? Yes, the defendant has threatened myself and my family. Have you been a victim prior? Yes. Does the defendant have any unaddressed mental health, drug, alcohol issues? Unsure, maybe mental health problems. Does the defendant own any weapons? Yes. Victim stated to our investigator, she is scared and worried about the defendant being released and retaliating against her. She absolutely does not want contact with the defendant. She applied for a TPO and she did not want to participate and have to see the defendant today. Your Honor, for criminal history, we have a contempt in 2022, no disposition, a contempt in 2021, no disposition, a domestic battery misdemeanor conviction out of Sparks Municipal Court, arrest for misdemeanor probation violation, and a fugitive arrest and he had a vandalism case in California, which might be what that fugitive arrest has to do with. 2 DUIs, one in 2019, one in 2017. Your Honor, based on the facts of the case, essentially he gets mad, throws her cell phone away, pulls out a knife, stabs her with the knife, drives her to Fernley, beats her up, and then when she agrees to move in with him, drives her home and then allows her to call the police. I think this gentleman is a significant danger to this victim and to our community. I think bail should be set at $250,000. And Your Honor, I am fresh off of leave, so my request is for the no contact order that you grant be done through the NRS that was recently passed for the no contact order that goes on the criminal history. I would ask for a no contact order through that and no contact order as a condition of his release.
For the defense?
Thank you, Your Honor. So as the state has indicated, there is an active protection order. It appears that Mr. Moreno was already served with that since he's been in custody. In addition to that, Your Honor, he is a moderate risk on the risk assessment. He has been previously successful on pretrial supervision as noted in the risk assessment report. He does have an apartment where he has been residing for the past 3 months. Which is mentioned in the probable cause sheet. He has lived in the area for nearly 6 years. He is currently working at Winco doing overnight stocking, that one on Pyramid out in Spanish Springs. He has been working there for 2.5 weeks. Prior to that, he was working consistently through Manpower for a year, and before that was painting houses for 3 years. He does have both a phone and an email.
See, that makes 3 of us. We're all having fun with Tim Hicks.
Email address to maintain contact with the court and his attorney and the Department of Alternative Sentencing for his pretrial supervision. He would be fine with a testing requirement, no drugs and alcohol, as he indicated that he believes, although he doesn't use substances or drink, he doesn't use illegal substances, and he doesn't drink or use marijuana often, but thinks that if he stops, it will be helpful for him moving forward to secure a better life for himself. As the risk assessment report indicates, he does not reside with the alleged victim in this case. He does not have any means to afford bail at this time due to the fact that he just recently started his job at Winco. But the court could put in place GPS monitoring to further bolster both the no contact order and the temporary protection order that he's already been served with, to ensure that he is not having contact or near the alleged victim in this matter, and could also impose residential confinement so that his whereabouts are significantly limited and only able to go
Welcome to Reno.
to work and home, again, to further protect any concern that this court might have for the alleged victim.
Thank you. These allegations are very serious and they involve multiple injuries, including puncturing the victim's skin with the tip of a knife.
We use the Imperial system because we prefer Death Stars and TIE fighters and stuff. That's why we use Imperial. Yeah. Enjoy your metric system. We've got a Death Star.
In addition to the other things that are described and took place over quite a significant period of time, allegedly. He scores an 8 on the risk assessment. That's a moderate. I will take that into consideration when setting the bail, but I believe that due to risks to the community, monetary bail is necessary. It'll be set at $100,000. That's bondable only. If he posts that, absolutely no contact with Brenda Perez, and that is pursuant to NRS 178.4845. That means, Mr. Moreno, is if you violate the no contact order, whether that's phone calls from the jail, text messages, seeing her in person, that is the basis for a completely separate charge. Not only would you likely be revoked on this case, but you'd be facing a new and separate allegation for violating this no contact order by statute. Additionally, there'll be house arrest with GPS location device before his release, supervision by DAS, testing for drugs and alcohol, and no weapons.
You're free to go. You're free to go, Tater Todd.
Well, Your Honor, you cut out with the last condition. I didn't hear what that last one was.
Oh, I'm sorry. The testing for drugs and alcohol and no weapons.
Thank you.
And supervision by.
She told them no weapons, not me no weapons. Phil, do not tell me how to live. Do not tell me how to live. Yeah.
DAS. Now we have Francisco Nieto.
Oh. And we're done. I didn't even remember I put that last clip in. So yeah, we're done. Yeah. Thanks for coming by. Thanks for stopping by. I'm not playing another video. I'm beat. I am beat. Third video, 6 videos in 2 days. It's a lot of videos, a lot of work. So I'm going to call tonight. Not do another video. You guys have a great night. Thank you for coming by. If you haven't already, please like and subscribe. That's all I got. That's all I got. Till next time. Bye. Let's roll that beautiful outro music.